Hi, I'm Sydney Calaby, Duke Law Class of 2025, and a student research assistant with the Duke Center for Firearms Law. And I'm your guest host for this episode of the Duke Law Podcast. Joining me on the podcast is Andrew Willinger, the Center's Executive Director and a lecturing fellow here at Duke Law. In this episode, we're going to be discussing an upcoming Supreme Court case that's garnering a lot of attention. The case is United States v. Rahimi, and it's the first major Second Amendment case to be heard by the Supreme Court since its landmark ruling in New York State Rifle and Pistol Association versus Bruen last summer. Andrew, it's great to be chatting with you today.
Thanks so much, Sydney. It's great to be here with you on the podcast today. And we've been watching and tracking Rahimi closely at the Center for Firearms Law. The case will be argued Tuesday, November 7th, and I'm really looking forward to our discussion today.
So before we dive into the details of Rahimi and discuss the legal issues at play, I want to point out a few reasons for why this case is so notable. First, the Fifth Circuit decision in Rahimi is one of a number of high-profile federal court decisions to strike down gun regulations under the historical legal test established by the Supreme Court last summer in Bruen. Second, Rahimi offers a chance for the court to clarify certain aspects of the Bruen test that have divided lower court judges. And lastly, we expect the court's decision in Rahimi will likely indicate how broad of an impact Bruen will have in the years to come. That said, Andrew, let's talk about the facts in the Rahimi case and the law that's being challenged here.
Absolutely. And first, I just want to say you're exactly right, Sydney, about the significance of this case. This is the first chance that the Supreme Court is going to have to clarify this new history-focused test that it set forth in a case last year called Bruen that you mentioned. Bruen really changed the way that courts evaluate Second Amendment challenges. And so in the year plus since Bruen, we've seen a lot of confusion and division among lower courts, including on the very law that's at issue in Rahimi. And the Supreme Court is now going to have a chance to step in and potentially clarify some aspects of the test. So the law that's being challenged in this case and that was struck down by the Circuit Court is a portion of the Federal Criminal Code. This is part of Section 18 U.S.C. Section 922G. That section lists a number of different status-based prohibitions on gun possession at the federal level. So probably the one that people are most familiar with, and certainly that prosecutors charge the most, is called the felon possession ban. That's 922G1. That says that if you're a convicted felon, it's a federal crime to possess a firearm for life. But this section of the criminal code contains other prohibited statuses as well. And one of those is that if you are subject to certain types of domestic violence restraining orders that are issued by a state family court judge, you are not allowed to possess guns for the duration of that order. And it's a federal crime if you do so. So that is the specific law that's at issue here. It's 922G8. And the actual facts in the case are, I would say, pretty unsavory and concerning. This case deals with an individual in Texas. He assaulted his ex-girlfriend. They were in an argument. It became violent. He dragged her into a car. And actually also took out a gun and fired at a bystander who saw this incident. And after this occurred, Mr. Rahimi agreed to the entry of a protective order against him. So his ex-girlfriend sought a protective order in family court, and Rahimi agreed to the entry of that order. That order did a number of things. It restricted Rahimi from seeing his ex-girlfriend, from going within a certain distance from her and their child, from contacting her, and it also prohibited him from having guns. And not only did it do that, but it was sort of a qualifying order for this federal law that I mentioned. So it became a federal crime for Rahimi to have guns while he was subject to the order. I should mention here briefly that I said the facts are unsavory. Rahimi went on to allegedly commit a number of criminal acts after the entry of this order. These are all allegations. They haven't been proven, but it's safe to say that he's facing a very long prison sentence at the state level for doing other things, including discharging a gun in various situations. But this case deals with his federal prosecution for having a gun while he was subject to a qualifying restraining order. And just briefly here, the sort of procedural history of the case is that Rahimi made a motion to dismiss his indictment under the Second Amendment. That motion was denied. He pled guilty. He then appealed to the Fifth Circuit Court of Appeals. And while his appeal was pending, the Supreme Court decided Bruen. And Bruen, as I mentioned, sort of changed everything in this area of law. So the court said, you need to go back and rebrief and re-argue this case because there's now a new legal test. And that brings us to the decision that's being challenged.
Thanks for that, Andrew. Now, the decision that's being appealed to the Supreme Court was issued by the Fifth Circuit earlier this year. What did that panel hold in that opinion?
Right. So the Fifth Circuit issued its ruling earlier this year, initially in February. It then withdrew that decision and reissued a very similar one in March. But the court breaks up this Bruen test into sort of two steps. You first have what's called a plain text inquiry that asks whether the law at issue and the defendant's conduct even implicates the Second Amendment to begin with as a threshold determination. If the answer is yes, then under Bruen, you move on to assess whether the law is consistent with historical tradition. So at the first step, the government had made an argument here that because Rahimi was subject to this protective order, he was outside the scope of the people entirely. He didn't even have Second Amendment protection, and sort of the analysis should end there. The circuit court rejected that view and construed the people to be pretty broad. So it said that, maybe somebody who's convicted of a felony, the analysis would be different, but this wasn't a criminal conviction that Rahimi had, and therefore he's part of the people. And so his possession of a firearm implicates the text of the Second Amendment. And so most of the court's analysis is on the second step of Bruen, this historical tradition step that sort of asks whether there are similar historical laws to the domestic violence restraining order ban. And the court considered three different categories of laws that the government had offered in the case. And it rejected each one and said that each category was insufficient. First, the government had pointed to group-based disarmament laws from around the founding era. A lot of these are discriminatory laws. These laws might have said that, for example, Native Americans or Catholics or Loyalists were not allowed to have guns or buy guns. And the court said that these are not appropriate analogs, in part because the groups that were targeted were not within the people protected by the Second Amendment at all. So these laws can't, in the court's view, shed any light on the scope of the Second Amendment. And the court also said that they may have been sort of animated by a different purpose because they were concerned with protecting society as a whole rather than protecting certain individuals. The restraining order ban really designed to protect the person who has asked for and received the restraining order. Second, the court considered a category of laws that it called the going armed laws. So these are criminal prohibitions on going armed to the terror of the people or similar verbiage. And the court said that these were not relevantly similar to 922G8 because they were criminal laws. They would have required a criminal conviction and all the attendant procedural protections as opposed to G8, which is based on a civil proceeding. And the court also noted that some of these historical laws did not provide for forfeiture of weapons, even if the individual was convicted. So they wouldn't have had to give up their firearms. But finally, the court considered this category of laws that are called surety laws. These appeared in America in about the early 1800s, and they required certain individuals to post surety or a bond before carrying weapons in public. The court actually says that these are pretty similar to 922G8. It's also a civil proceeding. It's not criminal. And there are other aspects that work similarly. But the court emphasizes that the surety laws did not ban possession of guns in the home. The court says they didn't ban public carry even, right? Because somebody could still carry a gun in public once they posted the bond. So after spending some length of the opinion walking through these different categories of historical laws, the circuit court concluded that there is no similar historical tradition that could support the domestic violence restraining order ban, and it holds that the law is facially unconstitutional, which means it's entirely unconstitutional under the Second Amendment. And there's a brief concurrence also in the Fifth Circuit by Judge James Ho. And he writes separately to say that he agrees with the historical analysis that the panel engaged in, but he also raised concerns about whether domestic violence restraining orders might be too easy to obtain and whether they might be misused in divorce proceedings.
Great. Now, we're just a few weeks away from oral argument set for November 7th. Both parties have filed their merits briefs at the Supreme Court. Tell me about the primary arguments in those briefs.
So yeah, as you mentioned, both parties have now filed their merits briefs. The government is going to file its reply, I think, any day now. And there's also been a total of 60 amicus briefs filed in the case, which is a pretty high number. It's about par for the course for these especially controversial Supreme Court cases. We've had some coverage and will have some coverage of the amicus briefs on our blog as well. As far as the merits briefs, so the government filed its opening brief back in July, I believe, and the government seems to mostly concede this sort of step one question about whether Rahimi is in or out of the people, because the government spends most of its space arguing that regardless of whether he's in or out at step one, there is a historical tradition of disarming persons who are not law-abiding responsible citizens. So that's the language that really appears throughout the government's brief, is that non-law abiding, non-responsible, that's the important historical principle that would justify disarming somebody like Rahimi. And the brief spends a lot of time summarizing various historical evidence in support of that argument, not just laws, but also various proposals and public commentary, legal compendiums from the 17th and 18th centuries, and argues that there's a widespread acceptance throughout British and early American history that non-law-abiding, non-responsible citizens can be disarmed. And then the government says that because people like Rahimi, who are subject to domestic violence restraining orders, pose a danger to others based on empirical evidence, therefore this law, 922G8, fits solidly within that historical tradition. And the government also criticizes the way that the Fifth Circuit applied the Bruin test. So the government seems to be saying you shouldn't divide up the historical evidence and look at each category of laws individually and determine whether individually that category is enough to support the modern law. You should really be conducting a more holistic approach and kind of adding them up. Rahimi filed his response brief a month or two after that. And Rahimi focuses on the scope of the statute. So Rahimi says this is a very broad law. It bans possession in the home and public carry for the duration of the protective order. It includes severe criminal penalties, I think up to 15 years in prison. And again, it's triggered by a civil proceeding rather than a criminal conviction. So those are a few of the things that Rahimi emphasizes in his brief. The brief also argues that on a historical analysis, that Americans did consider domestic violence to be a societal concern early on, even during the founding era and soon thereafter, but that they dealt with domestic violence in different ways. So they might have permitted divorce in certain circumstances or had various local law proceedings to deal with domestic violence. But one way they did not do that, in Rahimi's view, is by disarming the offender. Rahimi would require, I think, a pretty narrow historical or close historical analog, as the Fifth Circuit did. Again, Rahimi emphasizes the broadness of the law, says this is distinct from any possible historical analogs that the government might come up with. Rahimi discredits the government's historical evidence as sort of a collection of stray comments rather than a robust historical tradition. And then Rahimi makes a couple of arguments that are actually not based on the Second Amendment, but sort of offer alternative grounds to affirm the Fifth Circuit's ruling. So first, Rahimi suggests that the procedural protections in these underlying protective order proceedings in state court are insufficient. For example, Rahimi was not represented by counsel in the family court proceeding. So Rahimi suggests that there are due process issues with the law for that reason. And then Rahimi also argues that it might even be at a threshold level beyond the scope of the federal Commerce Clause power to even enact a law like 922G8. The background there is that sort of the reason this is part of federal law is that there's a jurisdictional hook, and the law only applies to firearms that have traveled in interstate commerce. But Rahimi says that that's sort of ahistorical and is too broad an interpretation of the Commerce Clause.
And for our listeners who are interested in hearing more about Rahimi and what happens at oral argument, where should they go?
One place they can go is the Center for Firearms Law website and our blog, Second Thoughts. Also, right after the oral argument on November 7th, I'll be back here on the Duke Law podcast to unpack everything that happened, analyze the justices' comments and questions, and also offer some thoughts on how the court might rule in the case. And I'll be joined then by my colleagues, Professors Joseph Blocher and Daryl Miller, fellow Second Amendment scholars and faculty co-directors of the Center for Firearms Law.
That all sounds great. In the meantime, thank you so much for joining me on the Duke Law podcast.
Thanks so much, Sydney. Really enjoyed it.
Be sure to follow the Center on X, the platform formerly known as Twitter, at Duke Firearms Law. And if you aren't already, be sure to follow the Duke Law podcast on Apple Podcasts or wherever you listen to your podcasts. Until next time, go Duke.